Well, hello. My name's Kim Mcleod. I'm a parent educator here in Ottawa, and I helped co-found a parent support group for special needs families called One More Thing. Our group is very specific to children who have a physical disability, and it's peer mentoring. Basically, it's a great place to go and resource information to find out where the funding is, to find out who the best lawyer is in Ottawa, to find out from families who've had lived experience what's worked for them. So that community is sponsoring, I guess, or in partnership here today with you, Ken, and very grateful that you've provided such valuable information for our families. Thanks for the opportunity.
Thank you, Kim. Your group is over 900 families now, eh?
That's right. Yes,
It's pretty sizable.
it is.
My practice focuses on a provincial and to some extent interprovincial basis on wills, trusts, and estate planning, guardianship, and so on, specifically and almost exclusively for families with children with disabilities or special needs. And it's a womb to tomb arrangement where you may come to the firm when the child is born. 6 months later, you come and see me because your son was born with Down syndrome. And at the other end of the spectrum, perhaps you're 95 now, your wife has predeceased you, and you want to make sure that your daughter, who still lives with you, is going to be provided for when you're gone. And then all of the things in the middle, ODSP applications and benefit increases and legal guardianship. And then, of course, at the end of the day, probate applications and Henson trust setup and so on. So what's happened since February 26th of 96, when I first started this work? I was called in 80, but didn't start this work till 96. And, as time went by, I just saw things that clients needed. And there's usually answers or partial answers to most problems. So we just adapted and adopted and came up with solutions. For example, we started legal guardianship back in 2009 because 2008 RDSPs came into place, but that large proportion of the population that's not competent couldn't have one because they weren't competent and they had no legal representative, such as a legal representative, a legal guardian, or even a power of attorney. So we learned how to do guardianships. Now we do them on a daily basis. It's quite busy. I would say these days we probably do more guardianships than wills, just because of the demand demographically. People. I won't to carry on further, but people do things when they get to the point either where they have a time to do it, which is where sort of harking back to one more thing, or when they realize that they just don't have peace of mind, and in order to have some peace of mind, they have to do a certain thing. So what we provide is variously through different tactics, peace of mind. It might be a will, it might be a guardianship, but that's what we really provide. So to give this discussion context, and the discussion should last about an hour, perhaps an hour and a quarter, I'd like to point out the number of families in the province that have a child with special needs, because of course a lot of families think that they're crazy and alone. Well, in fact, 1 family in 10 is a parent household of someone with special needs. If you factor in the sibling household, and presuming the parents are alive, then what happens is it's 1 in 5. And I know that because I have the statistics from ODSP. We get them updated. They're quite open with their numbers, if you ask politely. And what you can see here is that the population of the province is approximately 13.7 million. And what StatsCan says is that if you divide that by 3, that'll tell you how many households there are. So you can see that if you have this many households, 4,566,000, and if you have 378,000 people on ODSP between the ages of 18 and 65, if you factor in all the kids under 18 and all the seniors over 65 who still have disabilities, That's about another third. So say you factor in an additional 100,000. That would be relatively correct. So that would make you 478,000. And to be 1 in 10, you have to be 456,000. And this is just ODSP. This isn't CPPD or LTD or workman's comp or any of those things. This is just ODSP. So who knew, right? So here's the breakdown by type of disability. Now this pie chart could be better. For starts, it doesn't give me any kind of numbers on autism spectrum. Well, there was a question of where would traumatic brain injury fit into this, and again, it's not clear. But you can see more or less, to the extent that these numbers are useful, which they are, you can see the proportions. And you can see here that 19% quite likely are not competent. They may have limited competence, they may be competent in many ways, but you can see that 19% may not be fully competent. You can see that between psychoses and neuroses, there are people who may be competent, but emotionally not well, such that they're not competent to do certain things like manage money. And of course, there is a distinction. The person is competent sufficiently to blow their inheritance. All right, that doesn't prove they're incompetent. And then, of course, as far as the disability tax credit is concerned, that would include cognitive disabilities, and then these more physical or musculoskeletal, nervous system, and so on, as well as a number of people with psychoses and neuroses. So you can see that if you look at these numbers and think about it for a moment, a large number of these people, let's just say 50%, would or should qualify for the disability tax credit, and that they would then, not only would there be certain tax credits to recapture or transfer to a tax-paying family member, but they would then qualify to have an RDSP. And granted, it doesn't do much good for people over 49, but still, we're looking at a substantial number here. And then if you wish, you can take a look at these numbers. Take a look at your particular municipality. You can see the ODSP numbers, and you know your population. So if you divide your population by 3, such as Ottawa, about 1,333,000, let's say. Ottawa here has 26,000 people on ODSP. So if there's 333 households, that would be 33,000 people on ODSP, 1 in 10. And if you look at these numbers, plus the fact that people under 18 and over 65 are not included, I think it's pretty easy to see that conservatively it's clearly 1 in 10.
And these are pretty current numbers too, from February 2020, I believe.
Yeah, February 2020.
Okay.
I guess it's about time to get the new ones. They'll be bigger numbers.
Right.
You know, I've been doing this for some years, and every year they're bigger numbers. This is just a simple slide on a couple of the first things that we do for families when they fill out the family evaluation form. If the child is over 18 and living at home, and you can see here that borders 48,000. These are the kids at home over 18. So it's about 14% of the total number. But what that means is that they've been slotted into room and board, which is $896. And in a lot of cases, if they're able to shop or cook in some modest way, then we set up an arrangement, a shelter rental sort of arrangement, together with some shopping and cooking. And we then get the benefit increase to $1169. That work is done on a contingent basis. So if we're not successful, it doesn't cost anything. So we've done it about 800 times, I think, so far. Some years ago, I did a calculation, and I took the annual increase, the annual amount of that increase, and multiplied it by the number of families where we've been successful at that time. And it worked out to over $1 million that that we were able to improve for families a year. And then the other thing we do to try to put money into people's pockets is a large number of people have a child who either is approved for the disability credit, but they're not using it. You know, this is not uncommon. The most common profile is, for example, where a child went into supported living 20 years ago, and the parent stopped using the credit because they thought the child had to reside with them, which is not true. As long as you help to some extent with food, shelter, clothing, you can still transfer that credit. So we backfile it the 10 years that you're allowed, and you recapture about $16,000. And if the child is over 18, they either, if they're at home, or since 2017, if they're not at home, you can use the caregiver tax credit. And the typical recapture in most cases is about $9,000 for 10 years. So these are the first two things we focus on. Although a lot of times the factor that motivates people to contact us, fill out the form and so on, is their lack of peace of mind because they have no Henson trust provisions or no will, or they really know that they have to make some arrangement for legal guardianship so that when they're gone, their longtime family friend who's a child's age now as a young adult, or maybe a cousin who has no other legal standing, can take over for personal care and property because of legal guardianship. Mm-hmm. So there's often something that primarily motivates people to contact us, but these are the things we look at first to try to put money in their pocket, which then allows them, generally speaking, to walk away with all the work done and money still in their pocket. Mm. These are just the criteria for ODSP. If you happen to have a child who's over 18, can't function in the competitive workplace, and is not receiving ODSP benefits, then that is the highest and simplest test. And then, of course, if they can't handle, they can't function in the community or can't handle personal care, well, that's more obvious. So there would be fewer of those families that aren't receiving ODSP. The gift rule is now $10,000 over 12 months. You may have heard most recently the $6,000 gift rule, but that changed as of September 1st, 2017. So it's been a while. So now it's $10,000 asset test. Gift test, and the asset test for a person is $40,000. It used to be that you could receive 6,000 and keep 5, which caused, aggravation. Mm-hmm. This is a new thing since September 27th last year. It deals with families who have kids under 12 who, like for example, one of my staff is home with her son now because he had a headache, so they sent him home to get a COVID test, and now he has to quarantine for a day to get the results. Well, if you had to stay home for a 2-week period, for example, with a child, you could get this caregiver benefit, and it also applies to parents of children of all others. You have to stay with the child at home. You can't work at least 50% of what you did work due to having to provide care because of COVID, or because the supports like the outside programs that many people have had to step back from, over the last year.
Yes.
You can't have if you couldn't have PSWs come into the home and you couldn't send your child out to programs, well, I think it's pretty obvious what you have to do. Now we do a lot of work getting people approved for the disability tax credit. These are people that either didn't know about the credit, which still happens fairly frequently, or they applied themselves and had a doctor fill out a form, but Canada Revenue pushed back and didn't allow it, and they gave up. Or one of the slippage points that a lot of families don't even know about is that you send in your T2201 signed by the doctor, and then unbeknownst to you, because you're not notified, the doctor gets a letter asking for some supplementary information. So they respond just the same way anybody responds when they get a letter from Canada Revenue. What the heck is this? So they open it up and take a look at it. And what it is a letter asking them to confirm again what they've just said. And the problem is that it gives you 3 boxes to tick under whatever heading or category of restriction there is. A is no, just fine. B, problems, but intermittently. And C, serious all the time. So what happens is the doctor, who often only sees the child when they're up to their best, or doesn't want to be called out on anything, ticks the B box. Yes, it's serious, but not constant. You know, that sort of thing. So then what happens is CRA turns the application down.
Mm.
So what we have to do is we have to handle this whole process, see that the T2201 is properly completed. We draft them up and send them to the doctor, either to sign or to take the notes off of it and fill in the form themselves as they may wish. But we have to monitor the system online to see if that letter was sent, because a lot of times either it's not responded to, doctor just doesn't do it. No harm, it's just more paper for the doctor. But either they just don't do it, set it aside, forget, or they do fill it in, but in such a way that the person is then disqualified. So it takes a bit of patience and foresight.
And I have a quick question for you.
Sure.
Going back to the CRCB, 2 slides back. Is there an age limit on that?
For
Does it have to be 12 and older?
For the caregiver benefit? Not that I'm aware of.
Okay.
I haven't looked at it since around about September 27th.
Okay.
Followed it quite closely at that time.
Okay, well, I'll follow up with that later then.
Yeah.
Thank you.
Because lots of people are being affected.
Mm.
Now, the key though, the thing you have to sort of keep in mind first is that the person to whom this benefit applies has to have earned at least $5,000 in the previous year.
Right.
So this isn't for all of the permanent homemaker caregivers. This is for the people who were working.
Got it. Yes. Thank you.
The caregiver tax credit is a very little used credit. We're going to have to make some adaptations perhaps to our family intake form, because we find a lot of people tick the box that they do use the disability credit and tick the box below it that they do use the caregiver credit. And although we have put the lines on the form on the box beside the boxes, I find consistently that people tick both boxes because they think it's the same, or sometimes they skip the disability box and fill in the caregiver when they mean disability. So, you know, we try to untangle this, but I'll have to try to make the form even clearer. But what happens, the big thing here, is that as you can see here, you can recapture a certain amount of money going back 10 years. But until 2017, that only applied if your child was over 18 and resided with you. And you can see that only 14%, 48,000 people, have the child at home.
Right.
So in 2017, what they did was they removed the reside with criteria. It saves $1,000 in taxes each year, and it applies even if the child doesn't live with you, if you are still a caregiver.
Okay.
And that applies even if the disability credit has not been approved. It's not related to that. And I'm sure that of these 378,000 families right here, where they're clearly, their child is over 18, that a majority of them are in fact caregivers. So what that means is it's 378,000 times $1,000 a year, which I think is a great idea. And this is the line you look at. It would be possible that some families will look there and see nothing when they are in fact using 30425, which is the adult dependent. So that would be fine too. But the adult dependent with a disability is 30450. If you're approved for the disability credit, you can have an RDSP. And short story is that once the child's 18, if you do nothing, you open one and do nothing, child gets $1,000 a year for doing nothing. And if you put $1,500 a year in, They get a further $3,500 in grants for 20 years, up to age 49. And if you were to invest that money from age 18 until age 60, at which time it starts to pay out, you'll see that it amounts to approximately $700,000. It's invested at 5%, sorry. It's invested at 5% compounded. And we find that that's not, even in today's world, that's not excessive. It's consistently doable. And it winds up at age 60, paying out at about $32,000 a year for the following 23 years. So here's a bit more calculation for you. I'll just give people a moment to read that.
So is the RDSP age related, 18 and older, or can you start investing before the age of 18, as long as you have your disability tax credit?
You start before age 18, but at that time, grants and bonds are based upon the parent's household income.
Okay.
At 18, it's the child's ODSP income.
Okay.
So unless you're, well, I would say that most two-parent families, their income is greater than $35,000. So the child then wouldn't get the bond, but he would then catch them all up when he's 18.
Got it. Okay.
And if the household income is greater than 95,000, which there are lots of households of it like that, then the most you get in the grant way is if you put 1,000 in, you get 1,000, which is still better than kicking the pants.
Mm-hmm.
But you know, if this dawns on you when the child is 12, well, okay, so you're going to put in 1,000 and get 1,000 for 6 more years, or you're going to wait till the child's 18, use that 1,000 for something for the child, because that's my experience. Is a lot of it, my family's that $1,000 has a place to go, and if you wait till the child's 18, you get all the maximum grants and bonds for the full 20 years, and that's the same result. It is true that you won't get the compounding effect for those 6 years on the $12,000. Here's the formula to calculate, and this is, you could Google RDSP savings calculator if you want, but this is, I'll give you a moment to look at this. This is the calculator that indicates how much would be there under this scenario. Now, this is a never before thing. These plans have been in place since December of 2008. People were given until the end of March 09 to make the 08 contribution. A lot of families have, all the way through. And if this child qualifies for the disability tax credit, they could simply have a physical impairment. But if they have a cognitive impairment and they're not competent, then when they pass on, they may have reached age 60 and they may have started to receive payments. But if they die at age 62, the balance of the money is still then given to their estate. And because they're not competent, there's an intestacy, there's no will. And then by succession law, if the parents have survived, which is unlikely, the parents would receive the money. If the parents are deceased, then if there are siblings, the siblings would get it. If a sibling has died leaving issue, their child gets it. And if all of those people are gone, well, then it goes up and over and down, simplistically speaking, over to the cousins, all cousins. But this has never happened before.
Hmm.
To give this some comparison, when these individuals turn 60, 65, the ODSP will cease because they would be receiving RDSP payments, LDAP payments. Starting at age 60, they would stay on ODSP. At age 65, they would then be senior citizens. They'll get old age security and guaranteed income supplements. OAS is about $7,000, and the guaranteed income supplement is $11,000. That's $18,000. That's what a person with disabilities getting off ODSP would have then lived on before RDSPs. These are just some simple calculations here. You can see how these numbers are calculated. I don't think you need to go into detail on this.
And this is available after.
Yeah.
The quote.
Yeah. And look at these things a little, closer to age 60. And again, this is more detailed than you need as well. We do have one file now where we're arranging the payouts onto this SDSP because the brother with Down syndrome also has a expected shortened lifespan. He has dementia as well.
Okay.
Now this one is interesting. At a certain point, parents get to be at what I call the awkward age. And that's the age where they are older. They're not close to passing on, but they're older, they're concerned. And they've come to realize that, maybe they've done their will, perhaps they have a Henson trust, maybe they don't. Maybe that's what brings them to us. But what happens to the child? Who manages the child's property is RDSP. Who makes medical decisions for this not competent child when the parents are gone? Because typically when the parents are alive, they've either historically gotten the cooperation that they've needed generally, or they have, proceeded with guardianship because they've had some issue. But often people, while they're alive, they have decades of working with the same doctors in the same bank and so on.
Mm-hmm.
But then when they pass on, well, the siblings, the sisters and brothers or cousins, they just don't get the same clout. And there's no clear demarcation about who is now the legal representative for this child, this adult child. So what we do is we apply for guardianship. It's a paper process. It's called a bucket application. It's now done all done online. Used to be we'd actually take stuff and dump them in the bucket. But there's also a lot of paperwork involved, of course. But we don't try to sell guardianships because they're expensive. They cost thousands of dollars. But many families can afford it, or make sure that they do afford it. And it's part of the succession planning for the parents. They've done their will, they've done their Henson trust. The child has an RDSP. They've done all they possibly could, but they know that one day they'll be gone. So what you do is you apply for guardianship, typically with the parents and also others, siblings, perhaps cousins, maybe younger family friends. That does happen. And then when the parents pass on, it's not a matter of succession, but there are then surviving guardians. You're appointed by the court as a joint guardian. In practice, this doesn't really cause any problems. I won't go into that, but it's not really a practical problem.
Ken, what if you can't afford guardianship? What if you can't afford to pay for that? What happens?
You got a problem.
Okay. Good answer.
Because there is the public guardian and trustee. In rare situations, what happens is there is nobody. So, guardianship would be a nice idea, but there is nobody.
Okay.
So in rare cases, what you can do is you can have the child found not competent and then put into the bureaucratic hands of the public guardian and trustee's office.
Okay.
So there is somebody. Otherwise, obviously we have payment plans and so on, but you can't ask the capacity assessors to not be paid. You have court filing fees that have to be paid. There's a fee for the public guardian to review this stuff. They have to be paid. And we can't do it for free. We can try to be as moderate as we can, but
right.
What can you do from a practical perspective?
Ken, I know that you said at the beginning too that you had a poll to run today.
Thank you.
We're
Appreciate
about halfway through, maybe?
Yeah, we have 233 people.
Maybe they'll answer some questions on that poll.
That's great. Thank you.
No
A
problem.
little sticky on my screen, but I've ignored it. So I'm clicking the box that says allow panelists to vote, and I'm going to launch polling. And if everyone out there would be kind enough to make a choice to the best of your ability.
It's there, so it's working perfect.
Yeah, it's great. Eh? And we'll wait a few minutes, not long, but just a few minutes. And then I'll share the results. And what we're trying to find out is whether these sessions should always be done as couplets. Should there always be an evening and always a lunch? Or is it just that, it's just random and people did one or the other because that's what they felt like that day? Interesting. You'll see this in a moment. Little drum roll. Oh, that's just fascinating.
Just while we're waiting for that, I know that this is a hot topic, guardianship and power of attorney, and for families whose children are coming up to 16 and moving through to 18, it becomes a very confusing time.
So can you
Look
see
at that.
results there?
Mm-hmm.
So I presume everyone can see these results, eh?
Well, just in case they can't, it says 44% weekday lunchtime works best, and 44% said lunchtime or evenings works for us. And then 12% said weekday evenings work best for us.
So only 12% actually prefer evenings.
Mm-hmm.
Now, why is that?
It just wasn't the right day.
Maybe. We normally do our events on Wednesday evenings. This time we did Thursday. We had 538, I think it was, how many did we have registered, Karen, for Thursday? Was it 538?
584, and I think 530 attended.
Yeah.
Now with this poll, 44% says either or, right? Lunch or evenings.
Right.
44% would do either. But
that's true. Thank you, Karen.
44% say weekday lunch is best. Same number. That's interesting. And 12% say weekday evenings is best. That's very surprising because, of course, we had 580 whatever registered and 358 for lunch.
Yeah.
So I'm not sure quite how to unpack those results.
You can think about it over your lunch hour.
Yeah, exactly. We're doing well here. It's 12:35, so we're doing good. Now, powers of attorney are much less expensive. You're looking at something like for example, $600. If you want us to witness remotely, then that's another small fee, but still, you're looking basically at $600 because most people get neighbors or friends to come in as witnesses. And what this means is that from a very practical perspective, if your child is not so clearly not competent that people would laugh at the fact that you present them with the power of attorney, then if they'll hang their hat on it, and in lots of cases they will, like for example with Canada Revenue, all you're trying to do is file their taxes. Well, why would anybody block you from filing their taxes? There should be an even simpler way to simply state my child is not competent or some such thing. But otherwise, what you do is you prepare the powers of attorney or the standard CRA representation form, for example, and you submit it, and then you can access everything online for the child. Because of course you have to file their tax returns, not because you have to file them, because of course if you don't owe taxes, you don't have to file. But if you don't file, you don't get the various grants and subsidies and green energy whatevers that you get, which work out to be about $900 a year these days. But all these things together. But also, if you don't file the tax return, then the government, for RDSP purposes, doesn't know your income. So you just don't get grants and bonds. Well, that means you have to file. So, we're prepared to prepare forms and assist with powers of attorney wherever the child is reasonably competent. And then if the time comes that it's clear that they aren't going to be, that this is a waste of time, that the day is coming when the legal guardianship is going to be required. So why beat around the bush about it? Well, then we would opt back for that choice, especially if it gives the client more peace of mind. Substitute decision makers, in most scenarios here, that is the parents if the child is not competent. They are the statutory substitute decision makers. The problem is that then you get into the gray area of when the child appears to be competent, because then you're only the substitute decision maker if the child is not competent. So what you fall into is the privacy hole, the catch-22. Oh, well, they in fact actually they present very well. So I'm afraid I can't tell you about the treatment. Right? So this is power of attorney for personal care. These are the things to consider.
And there's 6 areas of life for power of attorney, isn't there? Personal.
I'd have to go back and look at one of the capacity assessments.
Okay.
There are cases where we have people assessed to determine if they're competent or not, so that we can determine if we can go, possibly, if we can at all, go with just power of attorney because we've had the child assessed and they're competent.
Okay.
It might be a gray area to somebody, but not to us after the capacity assessment is done. And here's information about substitute decision maker. Just note that it's only for personal care.
Right.
And a few times what we've done is the only issue seemed to be personal care, and being the substitute decision maker on the face of it wasn't giving the parents enough clout. So we prepared a heavy spiral bound package that had affidavits and documents and proof of birth and proof of parentage and all that. And then my cover letter, and part of the letter says informed consent in bold. And so what this does is it makes the doctors and hospitals and so on aware that a lawyer's involved. We know about informed consent, and here's the proof of the substitute decision maker. So give us some weight. We haven't done it often. People typically opt for guardianship, but there can be cases where it's sufficient. And this is some more information about guardianship versus power of attorney. We do have situations where it's awkward because the child may have some emotional health issues or perhaps fetal alcohol effect. They may lack judgment. They may lack inhibitions. They may be easily led, may be vulnerable. They may be spendthrifts. Not that you have much money on ODSP, of course, in poverty anyway, but some people come into inheritances and there is no Henson trust, which can do a lot of harm to a kid with a lot of money too soon, And the fact that somebody has an emotional health issue and spends the money in a way that we think is unwise or imprudent, that doesn't mean they're not competent. This is an interesting aspect. It's not at all well known that if you have a statutory provincial pension, which is pension for teachers, municipal employees, hydro power generator, or WSIB, workman's comp, those pensions, some of which can be quite sizable, like teachers have been in the business for quite some time and they have good pensions. So if you have a $60,000 indexed pension and you pass on, your spouse, if they survive, you get approximately 2/3 of that pension. But if you have an adult dependent surviving child, an adult dependent survivor, which is subject to being proved, but if you have an adult dependent child just with a disability, then they stand to receive 50% of your pension. So $30,000. Now, of course, there's several issues here. One is, are they competent to apply for it and to manage it? That brings us back to legal guardianship, which in these scenarios, we're pretty capable of predicting whether they could manage the money, if they're competent, and if they will certainly get the pension. You can usually make a pretty fair projection on these things. So who's going to apply and who's going to manage this pension? And of course, it does disqualify the child from ODSP, but then 30,000 is better than 14,000. Now, I won't go into this, but starting this tax year, for the filing in March of next year, the paperwork and the disclosure requirements for trusts is becoming more burdensome. Used to be that trusts were like people. If you didn't have any taxable income, you didn't have to file a return even. But in the sense of, black market money and money laundering and international transfers, we're all familiar with, FinTrack and those sorts of things. I mean, you go to the post office, you want to send a package to the States, you have to fill out a customs form now.
Yes.
So I'm not going to go into these matters, but starting this year, we'll have to give more specialized advice to the trustees of trusts. One of the big issues, of course, is if you don't comply, there's penalties. If you have a Henson trust, these are the basic essential words. So if you have a will, you have a trust, you're not sure, it doesn't say Henson Trust, most of them don't. We of course include that wording so it's clear, but these are some of the essential pieces for the trust to look for. And one of the most common misconceptions is that the trust itself is limited to 100,000, or that it can only disperse for the child up to 10,000 over 12 months, which is not true. This factor, lifetime benefit trusts, lots of people will die with sizable RRIFs. Let's just say $500,000. And yes, it's true that if a child has an RDSP, that they could put up to usually about 170,000 into that RDSP. That's true, you could shelter it that way. But if you have a child with a cognitive disability, you can set up a thing called a lifetime benefit trust, and you can roll any size. Roll is not really what happens, but you can roll a RRIF of any size over into the LBT. What it does, the only thing it can do, the trustee buys a qualifying trust annuity based upon the child's expected lifespan, essentially, with a guarantee period of, let's just say, 20 or 30 years. What we do is as you'll see on the next slides, we calculate what the annual payment would be given a certain amount of money, and then we multiply that. What we do is we calculate how long the child is expected to live. But what we do is we take the annual payment and divide it into the capital amount that's settled to buy the annuity, and then we guarantee the annuity for at least that period, as you'll see, so that what happens is, at the very least, all of the money comes back, and it either comes back payable to the LBT with the income attributed to the child, but not the income not paid to the child, or if the child dies prematurely, the annuity pays back whatever amount would be remaining to the trust, which then distributes it to the trust beneficiaries, the other siblings, for example. And here's one calculation. You can see that these are simplistic. I know that part. But you can see that if the RRIF is 500,000 and you die in December as compared to January, and you don't have your other income that year. So if you die in December, then if that person happened to be in a top marginal bracket with these additional dollars, 500,000, which at some point these dollars are in the top bracket, right? Even if you have zero other income. So we just for simplicity take it at 50% on the whole amount. So you pay tax at $250,000, which means that your child, your estate gets half and the government gets half. Now, if anybody, asking questions would like to put in an answer instead of a question about just how this is justified and correct and right and equitable and fair, I'd look forward to your answer.
Well,
Now, if instead you took that 500,000 and you set it up into an annuity with even just the 20-year guarantee, which doesn't cost very much at all, because most children, in these kind of scenarios would be expected to live another 20 years. So you're not paying much for something that you're going to get anyway, probably. What it would pay for 20 years is this number. And since the person has a personal tax credit plus a disability tax credit, this is our scenario. You could, of course, have a cognitive disability and somehow not be approved for the disability credit. That's true. But if you have your personal and your disability credit, you can see that of the $24,000 of income attributed to the beneficiary, only $3,000 is taxable, which means that they pay, or the trust pays for them, $708 a year. And you do this for 20 years, just for simplicity of the equation, and you pay $14,000 instead of $250. What do you think? You can see the savings here. And then this is the same calculation, but for a lesser number. And if you run these numbers, you'll see that there's no tax payable at all. Instead of $137.5, you pay nothing. These are some, this is vocabulary that you might want to have. Qualifying disability trusts, you can elect, if a beneficiary of such a trust is approved for the disability tax credit, you can make a qualifying disability trust election. And then if you decided to have income taxed in the hands of the trust, it would pay tax at beginning marginal rates. So, for example, 22% on the first 50,000, for example. These are graduated rate estates. An estate for the first 3 years for 4 tax year ends pays tax at marginal rates like a person. The typical method is to attribute income from the Henson Trust to the beneficiary who is approved for the disability credit using what's called a preferred beneficiary election. So you simply elect between the trust and the person, the beneficiary, or their legal representative, which brings you back to legal guardianship. You elect each year to attribute the trust income to the beneficiary to make use of their personal credits or their marginal tax rates. If the beneficiary of a Henson Trust is approved for the disability tax credit, then if the trust owns a home for them, it can qualify by way of election as a principal residence. It's owned by the trust, but resided in by the beneficiary, and an election is made each year to elect to have the principal residence exemption. So you can see here that if you think this through for 20 years, eventually one day that child dies, the home is sold, and under today's regime, at least, the proceeds are tax-free. Now we're coming to the end of the presentation, but this is the last slide here. A lot of people work hard, but when you look at the numbers, 75% of all people that file tax returns report income of less than 50,000. 75% of income reporting Canadian taxpayers report income of less than 50,000.
Huh.
So how much money have they accumulated? Well, if they purchased a house 20 or 30 years ago, when they die, they could be millionaires, but not before. But let's just say that 35% of Canadians are not homeowners even. That's not that far off. It's actually, it used to be 65% homeowners, now it's 60. Well, if you don't accumulate equity in a rising housing market, what you could do is you could buy some life insurance. And what you'll see here is that if you're a female, age 50, non-smoker, you're expected to live 35 more years. If you buy a universal or fixed life insurance policy, permanent life insurance, that pays $100,000, just as an example. When I made this slide, the calculation was that the monthly premium would be $115. That's $1,384 a year. Now, bearing in mind that 14% of all families have a child at home who receives $896 or $1169 per month, and could therefore theoretically afford this premium to have insurance payable to the Henson Trust on death. If you thought that you were going to save that money, you're going to invest it and pay tax on what you earn. Let's just say, simplistically, if you save the premium for $100,000, taxes and inflation, all that stuff aside, you'd have to save it for 72 years. You're only expected to live 35. So it's unlikely to happen. Speaking as a lawyer with an abundance of caution, I don't think you're going to live that long.
Right.
So you could never do it. So you could consider spending this kind of annual amount such that at the time of your death, your trust receives at least this, plus whatever share of the estate goes to that child if you have several. And that's about it. I know that Karen Christie and Diane Verano have been fielding questions. I don't think I told you, Kim, but in the hour and a quarter we did the session last Thursday night, they answered 150 questions.
I saw the numbers of questions that went through.
Well, I don't know if they're going to beat that total today.
Well, they've answered 65 so far, so.
Oh, that's good.
Yeah, there's just 21 left.
Oh, I see. Yeah. Yeah, so answered. Yeah, 67. That's pretty good. And of course, we're only coming up to the 55-minute mark. We were an hour and a quarter last time. So now, because it's lunch, I think I will close off at noon. I'll just put this screen up on this slide up on the screen. The simplest way to to contact us is to go to the website, perhaps to download the Henson Trust ebook or the Guardianship ebook, and then you'll be given a link to a family evaluation form. The family evaluation form is also under the contact drop down on the top right. And what this does is it's a short 2-page form. It's an expanded form of the webcast registration form, but not much. And it comes to myself and to Karen, and we then make an initial assessment of what perhaps should first be done, and email back, and if appropriate, set up an initial short courtesy discussion. And then if it turns out that people would like our assistance, then we'll talk about fees and see where that goes. So we got about 4 minutes. I'm going to start looking at some of these questions as well. Kim, can you see the questions?
I can, yes.
Oh, good. Okay.
Yes, I can.
If a family makes over 90 grand a year and the child is under 18 and has an RDSP, is it better to wait? I apologize for that. If a family makes over 90,000 a year and the child is under 18, common scenario, and has an RDSP, is it better to wait until they are over 18 to continue making contributions? Well, my policy answer is yes, but obviously policies are just to help you not have to think. So from a policy perspective, yes. If you have a spare $1,000, fine. A common scenario in Ottawa here would be a civil servant of a reasonably senior position, making something in excess of 100,000, 110, for example, a little bit of overtime, and a parent, often the wife, at home, single income household, and their household income is over the threshold for getting only 1,000 for 1,000. But my experience is that if a family is making $100,000 single income, it's not that they're rich. They're no different than a two-income family where they each make 50.
Mm-hmm.
Right? They may perhaps pay more taxes because 100,000 is treated as more rich.
Right.
So I don't see the equity in that. But that's my mini rant for the day. So, if you have a place for that $1,000, don't stick it in the RDSP. You can't take it out if you need it. Set it aside even in case you need it. But then when the child turns 18, what you should do is at age 16, you should start filing tax returns for that child, a nil return, a zero return, because they have no income, but you file the tax return. So for the 2 years prior to age 18, you file tax returns so that it's on record that the child has no other income of their own. And then when they turn 18, then they should start to immediately get the grants and bonds because they're 18, and the presumption is that their income will be the same as in the 2 prior years, zero. Well, in fact, it'll be ODSP, of course.
Right.
At the maximum, it'll be 14,000, but it's a social benefit, so it's not taxable. So yes, it's true that there is more income, but not sufficient at 14,000 to disqualify the $1,000 bond, and certainly low enough, obviously, to result in 1,500 contribution, receiving 3,500 grant. So I would just wait. Now, if you happen to have a grandmother who wants to contribute $1,000 for the child's well-being, and you decide that you want to put it into the RDSP so she can concretely see that now it's 2,000, sure. Could you please advance the slide to the power of attorney slide as we were discussing now? Sure. Just a sec. So there's power of attorney personal. And is it personal or property do you think you want?
Well, they're going to receive this entire file also, right?
True.
So they can review that.
That's true.
Whenever it comes.
Would a hoop pension be applicable to the pensions going to the disabled child? No, not hoop. That's nurses, for example.
Okay.
Can a grandparent roll their RRIF into a trust for their grandchild? Well, you'd have to be talking lifetime benefit trusts, right? And the child would have to have a cognitive disability, but otherwise you probably could. It would be best if the grandparent prior to death was using their grandchild's disability tax credit, which would show the relationship between the two, and also the fact that in order for that credit to be transferable to the grandfather, the criteria is that the grandfather has helped to some degree with food, shelter, clothing, sufficiently to satisfy Canada Revenue that it is transferable. That would be prudent. I think that's about it. It's 1:03, Kim. Would you like to say any closing words? And we'll wrap up.
Yes, thank you very much. It's a lot of information. I'm so happy that you have packets available on your website that allow families to review the area that they're interested in, and that there is a consultation option with you. So that's wonderful. And yeah, kenpopelaw.com or kpopelaw.com. Thank you. I've appreciated having the opportunity to learn so much.
Well, I did too. You know, I always enjoy these presentations. The PowerPoint slides help me to sort of keep on track, but I usually wing it as far as the speech part. It's not like I have little cue cards, you know, because
Right.
I've been doing these on-site and online events since summer of '96.
Well, our community is lucky to have you, Ken. Thank you for your knowledge.
Well, I'm glad to help. So I'm going to ring off here, and for people that we couldn't answer all the questions, obviously, you're welcome to send us an email or simply fill in the family evaluation form, and then in the tell us about yourself box at the end, write the question in again, and we'll be happy to do our best to respond. With that said, good luck and good night.